He didn't see a threat, he invented one. Watching and laughing, that's not confusion, that's perjury. I tried to leave myself. I was stopped unlawfully. What did he do that made me stop?
He physically put his hands out and stopped you.
Correct. Illegal detention, the 43-minute private search of my briefcase, the altered citation. The citation was later altered, and when I subpoenaed the city for policies explaining how this could happen, they admitted in writing they have none.
Judge, Yes, Judge, and I hate doing it during closing. I understand there's a lot of argument with regard to searching a bag for 40 minutes, a number of facts otherwise with regard to policies and procedures that were never admitted into the record. Facts such as when I made certain requests, I wasn't given certain things. Those aren't in record. He made arguments as to that information, but we objected. It was
no policies, no oversight, no accountability. The city even moved to remove damaging language from its own complaint because it didn't have any truth that fit their story. That's not law enforcement, that's theater, and I refuse to play along. If the city truly believed in this case, they wouldn't have offered me 4 plea deals.
Objection, Judge. It's facts, not evidence, as well as the fact that that's not admissible. Negotiations cannot be discussed at trial. In the district attorney's office, and quite frankly, he was fine when he was first interacted with. He was normal, he was calm, he was collected. It was only upon exiting and when he started recording and he was confronted with that administrative order that things escalated, and it escalated quickly. Multiple people asked, give me your name. The answer was essentially, fuck you, no, or some variation of that. I believe that's the obstruction. We've proven beyond a reasonable doubt. We ask that you find the defendant guilty today.
Thank you, sir. All right. Mr. Ott, stand up, please. Mr. Ott, it looks like you submitted this on behalf of Las Vegas Corruption Line. So what is Las Vegas Corruption Line? Okay, thank you, City. Mr. Ott.
Yes, sir. Your Honor, what this courtroom has witnessed over the past few days is not justice, it's damage control. The entire case began because an investigator acted on a hunch, not a law. Jamie Honecker admitted that he called armed marshals not because I had committed a crime, but because he thought I might not take the advisement well. That single sentence destroyed the entire foundation of this case. That was the moment that truth left the room and fear took its place. He didn't see a threat, he invented one. And when the false call triggered everything that followed, the illegal detention, the 43-minute private search of my briefcase, the altered citation, the cover-ups, the lies, and now this trial. Then we saw the testimony. Honecker, under oath, told this court he was not present when I was handcuffed to a bench. The video shows him standing right there, watching and laughing. That's not confusion, that's perjury. Marshal G. Strong testified that I started moving towards jury services as if walking towards the exit was evidence of obstruction. Your Honor, walking towards the door when you're told to leave is not obstruction, it's compliance. Officers G. Strong, Adam Page, and also Honecker flat out lied, I'm sorry. They said that they asked me to leave in the hallway. The video evidence shows not one of those officers asked me to leave in the hallway. I tried to leave myself. I was stopped unlawfully by their sergeant. As far as when I started walking towards the exit, what stopped me from walking any further?
Sergeant's fees.
Okay. And what did he do that made me stop?
He physically put his hands out and stopped you.
Correct. These weren't harmless mistakes. These were coordinated falsehoods designed to justify an illegal arrest after the fact. Each one told a slightly different story, but every version had the same goal, to turn a citizen with the camera into a criminal. Let's remember what I was actually doing. I was recording public officials in a public building. I was recording law enforcement activity only after my non-consensual encounter with them. This is not a crime. That's a constitutional right protected under the First Amendment and Article 1, Section 9 of the Nevada Constitution. You cannot obstruct a public officer by documenting their actions. You cannot disturb the peace by quietly exercising a right guaranteed by every American, or to every American. If observing government workers in a space is now considered obstruction, then transparency itself has been outlawed. 7 officers were involved that day. Only 3 wrote reports. The one who searched my bag for 43 minutes wrote none. The citation was later altered, and when I subpoenaed the city for policies explaining how this could happen, they admitted in writing they have none.
Judge, I'm going to make a number of...
Right case. City of Las Vegas versus Philip Bach, case number 25-044911. Count 1, disturbing the peace. Count 2, obstructing a public officer. City, you're objecting?
Yes, Judge. I hate doing it during closing. I understand there's a lot of argument that's allowed to be done. However, at this point in time, he's made reference to a number of facts not in evidence, particularly with regard to searching a bag for 40 minutes, a number of facts otherwise with regard to policies and procedures that were never admitted into the record, facts such as when I made certain requests, I wasn't given certain things. Those aren't in record. He made arguments as to that information, but we objected. It was prohibited from coming into court. It was excluded. He's not allowed then to make comments about it during closing.
Okay. So, Mr. Ron, when it comes to closing, this is the time, like I told you, I kept telling you can't introduce commentary. This is the time where you can introduce commentary. This is the time where you can characterize things in a certain way based on how you perceive them, based on your theory of the case. So you can add more, for lack of a better term, more personality to the argument. This is persuasive. This is the time to be persuasive. However, what you cannot do is refer to things that are not in evidence. So whatever you may or may not have requested from the city attorney's office when it comes to written policies or documentation, there has been nothing introduced into evidence regarding those things. So you can't bring that up, and I can't consider it. Similarly, there was a lot of testimony regarding, and a lot of questioning, rather, regarding Marshal Spies when he was not in the interrogation room, when he was. But there has been nothing in the record to establish that he was searching your bag, that it happened for a prolonged period of time. So you can't reference those things. I understand those are facts that you feel are important to the case, but they are not in the record. You are limited to things that were introduced during the trial. I understand the city's objected to your closing. So if you want to take a minute and recalibrate, I'm not going to put you on the spot. But if you want to take just a minute and think about how you want to approach it, but you need to limit your closing to persuasive argument with the underlying facts and evidence that have been entered into the record.
Can I say something? Every time I try to make any kind of raising about anything that's not relevant to the charges themselves, like if I brought up the policies of searching, objection, I couldn't talk about it. So that's why we didn't hear anything about a 43-minute detention, about my bag being searched for 43 minutes. It definitely happened, and they knew it.
And whether or not that happened, I understand this is maybe difficult. This is, I'm sure, very frustrating to hear. Whether or not that happened doesn't affect whether or not you did what they're saying you did. That's what we're here to decide. Now, things that did happen that would either prove that you did it or discount the evidence supporting that proposition,
yes,
those things I allowed in. There may have been a lot of things that you feel that were not fair, that were not appropriate, but those things may not be relevant to the charges that are in front of me today. Like I said before, whether or not the marshals were rude or you felt like they didn't comport themselves in the right fashion is only relevant to the extent that it goes to their credibility. It is not relevant to whether or not you committed the crimes. So with that, I'm going to allow you to go ahead and continue your closing.
All right. I'm just going to start over and exclude everything that wasn't brought in evidence.
Okay.
Your Honor, what this courtroom has witnessed over the past few days is not justice. It's damage control. This entire case began because an investigator acted on a hunch, not a law. Jamie Honecker admitted that he called the marshals not because I committed a crime, but because he thought I might not take the advisement well. That single sentence destroyed the entire foundation of this case. That was the moment that truth left the room and fear took its place. He didn't see a threat, he invented one. And that false call triggered everything that happened. The alleged illegal detention, the altered citation, the cover-ups, the lies, and now this trial. The patterns of deception. Then we saw the testimony. Honecker under oath told this court he was not present when I was handcuffed to a bench. The video shows him standing right there, watching and laughing. That's not confusion, that's perjury. Marshal G. Strong testified I was moving towards jury services as if that were a crime, as if walking toward the exit was evidence of obstruction or disturbing the peace. Your Honor, walking towards the door when you're told to leave is not obstruction, it's compliance. And in fact, I was never told to leave. I left on my own accord.
He needed to leave.
And at this point in time, what was his demeanor?
I think he was a little shocked, a little surprised that we were asking him to leave. He was obviously not pleased.
Was he disruptive or loud at this point?
No, he actually got up and left the immediate office.
Okay. Do you know where he went?
He went out directly outside of the District Attorney Administration office.
And when you said, you asked me to leave, did I leave immediately?
You got up and left the threshold of the DA's office into the hallway, yes.
Right. Okay. So, did I comply with your request at that moment?
My request, yes.
Okay. So I was told to leave the DA's office, not the courthouse, correct?
By myself, yes.
Okay. Okay. And are you able to tell me who else might have told me to leave the courthouse according to you?
The District Court Marshals.
Okay. You know exactly who?
No.
Okay. So you don't know exactly who, but you can tell me that they did.
Yes.
And then at some point he was asked to come talk to us in the hallway, to which he complied and stated he would go outside and talk with us more.
You testified that he came out of the DA's office, right?
Yet when we asked to speak with them. Yeah.
Right. At that point in time, do you recall if you or any other marshals in the area had asked him to leave or advised him to leave?
He was advised that the DA office was requesting him to leave, and then he was informed to leave the building, and he stated something to the effect that he wasn't going to leave.
What did you observe about my behavior when I was asked to leave the DA's office?
I believe, I thought we asked you to leave, meaning to come out and talk with us, but you may have said, I'll go outside and talk with you. I don't remember if we told you to come out and talk with us, or you said to come out and talk with us. Maybe re-ask your question, I'm sorry.
Sure. Is it fair to say that I did comply with the request to leave immediately?
I wouldn't say immediately, because we had to talk with you, I'd say 1 minute before you left the office.
And at any point during this conversation, were you walking towards the elevator?
No,
So you were still just stopped in front of the DA's office?
correct.
And at this point, had you already asked him to leave?
Yes.
Okay. And once you radioed for Sergeant Spees to come with the copy of the order, what happened next?
So maybe a minute or two later, Sergeant Spees starts walking down the hallway towards us when when he saw Sergeant Spees, he turned off his phone and says, I'm leaving, and started to walk away towards the elevator, escalator, exit.
All right. So you testified that you personally asked me to leave several times in the hallway.
More than
Objection
once, yes.
answered.
Sustained. So you've asked him that
Well, I was
many
going to the
times.
next question.
Okay, go ahead and move on to the next.
Sure. Do you remember exactly when you asked me to leave personally in the hallways as testified to?
Okay, you keep on adding words. Just to be clear, I asked you to leave when you were in the lobby, not in the hallway. The hallway you started recording, and I had told you to stop recording.
Okay, so my next question is, did I hear the city prosecutor, did the court hear the city prosecutor ask you, did you ask Mr. Ott to leave in the hallway several times? You don't recall that question?
There's a couple questions there. Can you just give me one and so I can
Do
answer them?
you recall when the city prosecutor, they were directing you, they asked you, did you ask Mr. Ott in the hallway to leave several times?
An objection, Your Honor, in this case, I asked if he was asked, not if specifically Officer Page asked him.
She definitely asked if he...
I'm going to sustain the objection. I think it falls under the same asked and answered basis as before. So it's been testified to that this witness asked you to leave, quote, more than once throughout the entire time that he had contact with you.
Okay. So that trespass, before you trespass someone, walk us through that. Would you have to ask someone to leave first?
Yes.
Okay. And was I asked to leave in the hallway by anyone, including yourself?
I asked you to leave.
Okay. But you said several times, your story kind of, I'm sorry, I'm getting argumentative. So you asked me to leave. We'll just roll with it. But you can't recall when you asked me to leave, right?
Oh, I asked you to leave in the lobby.
You asked me to leave in the lobby. So exactly when?
Like, you want to know the time?
Yeah. Approximately how long from me us exiting the DA office into that hallway, which was described as 4 or 5 minutes. When in those 4 to 5 minutes did you ask me to leave and I did not comply?
Okay. I asked you at least 2 times, more than once, to leave. The DA's office wanted you to leave while you were in the lobby.
Okay. So it's 2 times.
I don't recall. Yes.
But you just testified you asked me 1 time. Now it's 2?
No, I said it was more than 1.
Okay. Which version do you want the court to believe today?
More than 1.
Objection argumentative.
Mr. Page, do you believe it was lawful for Mr. Spice to stop me?
Yes.
What was lawful about it?
You were recording in violation of our administrative order issued by Chief Judge Weiss.
Great.
Additionally, you did not leave the premises when I had asked you to leave.
Okay, you're going back to that, but when did you ask me to leave?
When you were in the lobby.
When I was in the lobby. Okay. You were aware that I reported the incident that day, right?
Am I aware?
Yeah.
If you
Also, were asked about on cross-examination about whether the defendant left. In your observations, was the defendant asked at least 1 time to leave the area?
Yes,
Okay,
even the building.
And I know he asked questions about did he take steps to leave, and there was some discussion about it, but in your observations, did he ever in fact leave the building until he was asked to much later?
After the citation was issued?
Right.
Yes.
Okay. So prior to Sergeant Spies getting there, did the defendant take any, did he try to exit, was at any point restrained or not permitted to exit?
Not that I recall.
Mr. Strong, do you remember me trying to leave the courthouse before T-Spires stopped me?
I do not remember you trying to leave. I remember you walking towards the way he was coming from.
Okay. So would you say that's leaving or just walking?
For me, leaving is actually exiting the building.
Right. Okay. So we were on the 3rd floor, is that correct?
Correct. As far as what you're describing now.
Correct.
Yes.
And with us being on the 3rd floor, you just said walking out the door. So with me picking up my bag and my keys, stopping the recording, and walking towards the exit, would you say that's attempting to leave the property?
I don't recall you picking up your bag. I remember you dropping your bag at the point when you were saying, take me to jail, and the point that you went in the corner, as you said.
Yes, sir. All right. I would like to introduce an exhibit, Your Honor.
Okay. What is this?
This exhibit is going to be a video that shows I actually tried to leave right before I was unlawfully detained. As far as when I started walking towards the exit, what stopped me from walking any further?
Sergeant Spees.
Okay. And what did he do that made me stop?
He physically put his hands out and stopped you.
Correct. These weren't harmless mistakes. They were coordinated falsehoods designed to justify an illegal arrest after the fact. Each one told a slightly different story, but every version had the same goal, to turn a citizen with a camera into a criminal. Let's remember what I was actually doing. I was recording public officials in a public building. That's not a crime. That's a constitutional right protected under the First Amendment and Article 1, Section 9 of Nevada Constitution. You can't obstruct a public officer by documenting their actions. You cannot disturb the peace by quietly exercising a guaranteed right to every American. If observing government workers in a public space is considered obstruction, then transparency itself has been outlawed. 7 officers were involved that day, only 3 wrote reports. This citation was later altered when I subpoenaed the city or asking for their policies.
So, Mr. Ott, whether or not you subpoenaed the city is not a fact in evidence.
Okay.
It's not something I can consider.
The citation was offered 4 months after issuance, after G. Strong testified that the city had sent the ticket back to be altered. No policies, no oversight, no accountability. The city even moved to remove damaging language from its own complaint because it didn't have any truth that fit their story. That's not law enforcement, that's theater, and I refuse to play along. If the city truly believed in this case, they wouldn't have offered me 4 plea deals.
Objection, Judge. It's facts, not evidence, as well as the fact that that's not admissible. Negotiations cannot be discussed at trial.
So, Mr. Ott, the city's correct. You can't talk about plea negotiations during your closing, and that's not in evidence.
Okay.
So you need to limit yourself to the things that were introduced in the record.
This case isn't about obstruction. This isn't about disturbing the peace. This is about what happens when a citizen dares to record government misconduct and the system decides to make an example out of him. If the government can lie, alter evidence, and still win, then every citizen loses. If the truth doesn't matter here, it won't matter anywhere. So I leave this court with one question. When the evidence is tainted, the testimony is false, and the prosecution is fueled by retaliation, what's left to convict? The answer is simple. Nothing. Your Honor, the only obstruction here was the truth. The only disturbance was to the integrity of this justice system itself. I was not a threat that day. The truth was. I asked this court to dismiss these charges, to restore what's been broken, and to send a message that in Las Vegas, the law still applies to everyone, even those who wear a badge. Thank you, Your Honor.
Thank you, Mr. Ott. City. We're going.
Yes, Judge. I'll keep it quick. Your Honor, the defendant said that it cannot be disturbing the peace when somebody is quietly exercising their rights, and I think the evidence before the court shows very clearly that nothing about what the defendant did was quiet that day. He was charged with NRS 203.119. As my co-counsel stated, it indicates that a commission of an act in a public building or area interfering with peaceful conduct of activities, subsection 1, a person shall not commit any act in a public building or on the public grounds surrounding the building, which interferes with the peaceful conduct of activities normally carried on in the building or on the grounds. Sub 2 says any person whose conduct is prohibited by subsection 1, who refuses to leave the building or the grounds upon request by the proper official is guilty of a misdemeanor. You heard the clear testimony, as stated by my co-counsel, and as provided by the entirety of everybody who testified, that the defendant was on the third floor near the district attorney's office, or in the district attorney's office, and quite frankly, he was fine when he was first interacted with. He was normal, he was calm, he was collected. It was only upon exiting and when he started recording and he was confronted with that administrative order that things escalated, and it escalated quickly. You heard the testimony of multiple witnesses that he went from quiet and calm to extremely escalated. He was very agitated, some witnesses said. He started using profanity, started getting louder, more animated. All the witnesses described him as loud and animated. This also is important that it took place in front of the district attorney's office. As we indicated, the citation says it was on the RJC in the third floor. We have to prove beyond a reasonable doubt that it interrupted the normal course of activity in a government building. By all means, the RJC is a government building, and that we have to show that it interfered with the normal activity, which we did. We indicated that this happened, it started in the district attorney's office and went out into that little corridor outside. You heard testimony from a number of witnesses that there's the district attorney's office on one side, jury services on the other, which included where they were interviewing or bringing in new district attorney interns. You heard the district attorney's victim advocates was on the other side. I asked, and my co-counsel asked a number of witnesses, would this have impacted a normal person trying to go about their business with the district attorney's office? The answer unanimously was yes. You heard testimony that people were shutting doors. You saw in one of the videos as they're bringing the defendant down that he was being so loud and disturbing the peace of everybody in the entire courthouse that people were leaving and running away. You heard testimony from Lieutenant Tisano that even as he entered the room, the defendant was still yelling, which is indicative of his attitude and demeanor at the time. You also heard testimony from Officer Strong, who said that he was a duly appointed representative of the building, asked the defendant to leave. You heard testimony from a number of other witnesses as well, that the defendant was asked to leave. You heard testimony today from one of the officers that the interaction lasted about 4 to 5 minutes in the hallway before Sergeant Spees showed up. And during that time, the defendant did not leave after being asked multiple times to leave. He did not. It was only when Sergeant Spees showed up with the AO in his hand that the defendant decided, now's the time I'm going to try to leave. But he didn't for the entire 4 to 5 minutes before that. And that's where the disturbing the peace took place, when he was getting loud and yelling. It continued afterwards when he was yelling the entire way down. We believe we've proven our case beyond a reasonable doubt with that aspect. And as my co-counsel indicated, the obstructing charge, he was asked a number of times, you saw it on video, Judge. I need your name and I need your identifiers. I asked Sergeant Spees specifically, did you know this person? None of the officers who testified knew who Mr. Ott was. They weren't able to identify him off the bat. Jamie Honecker eventually was able to provide that information. But the actual marshals who were doing the investigation didn't know who he was. Sergeant Spees asked, give me your name, give me your date of birth so I can figure out who you are. Eventually, Mr. Ott did provide his name, but didn't provide his date of birth. I asked Sergeant Spees, was the name alone enough for you to identify him? He said, no, I needed something else. I needed some sort of way to identify who he was. The law in Nevada is clear that you have to provide sufficient information for a law enforcement officer to identify you. Philip Ott was not enough, as testified to by Sergeant Spees to this court. Multiple people asked, give me your name. The answer was essentially, fuck you, no, or some variation of that. I believe there was multiple expletives testified to. You saw that on video multiple times. Refusal to provide enough information to identify. That's the obstruction. We've proven beyond a reasonable doubt. We ask that you find the defendant guilty today.
Thank you, Sue. All right. Mr. Ron, stand up.